What do you look at when defending against a protective order application? When representing a respondent in a protective order case, one of the first things that I do is to thoroughly review the affidavit filed by the applicant if the applicant applied for a temporary ex parte protective order. Because an affidavit is necessary to have a temporary PO granted, more often than not, a sworn affidavit outlining the alleged incidences will be included in papers that were served on my client. I check this sworn statement for internal inconsistencies, and I ask my client to also provide a timeline of events so that I can check the affidavit against my client's story. I ask my client to provide me with any written correspondence between my client and the applicant, whether by email or text, and I check that against the statement of the applicant. Written communication is often a goldmine of evidence and information about the history of the relationship between the parties, and can be excellent cross-examination evidence to bring into doubt the veracity of the applicant's testimony. It's important for attorneys defending protective orders to remember that under the Family Code, family violence has a specific definition that includes threats. So you need to examine each alleged incident to carefully determine whether it meets the technical definition of family violence. If none of the incidents, if true, would meet even the statutory definition, then an attorney might consider moving for dismissal after the applicant's attorney rests at trial. If you are defending against a protective order and the evidence is strong that family violence has occurred, you can still assertively defend against a PO by addressing the second element, whether family violence is likely to occur again in the future. This may include testimony from your client about the client's desire to stay away from the applicant and showing the court that you do not intend to act in any manner in the future that would warrant a protective order. Ultimately, it is incredibly important that if you were served with a protective order application, you seek counsel to defend you at your hearing. While a final protective order is a civil court order, it is criminally enforceable, which means that you could be prosecuted in the future for any perceived violations. This could have a severe negative impact on your freedom, finances, and future employment prospects.